In a significant ruling, the Supreme Court has held that charitable educational trusts that are profit-oriented cannot seek any exemption from income tax. This ruling is likely to have wide-ranging ramifications. In fact, it's not restricted to education alone. It will have wide-ranging implications for a whole host of charitable institutions, from education to the healthcare sector to, of course, the management of sport as well. Ashmit Kumar joins us now to explain the court order and its significance. Ashmit.
Well, just to give the context first, the legislature has encouraged such charities by giving them exemptions from income tax since as way back as 1886. Now, Modern Income Tax Act also provides for similar benefits. However, it has been a decades-long struggle for the tax department to check the misuse of this exemption provision. Now, this debate climaxed in the Supreme Court with the court hearing as many as 110 pleas by the tax department against various high court orders. The IT department had challenged various high court orders that held that charities can undertake business and commercial activities and still claim a tax exemption. Now, under the Modern IT Act, Section 215 defines what qualifies as charitable purpose. Trusts engaged in relief for poor, education, medical relief and general public utilities qualify as charities. I'd lay emphasis on GPUs or general public utilities. That was the focus here as far as Apex Court is concerned. The Supreme Court was to decide what are the conditions under which these GPUs or general public utilities can claim tax exemptions. Now, but what are GPUs? Well, examples would include the likes of municipal corporations, state cricket associations, regulatory bodies like the ICAI, which is the governing body for chartered accountants, trade associations, as well as government not-for-profit bodies like the National Interest Exchange, which can also qualify as a GPU. Now, what's important here is that the Apex Court importantly has clarified in its judgment that under Section 215, it needs to be declared by the Apex Court that in broad terms, Supreme Court has that carrying out of commercial activities or levying fees will bar charitable trust from claiming exemption. Now, the Supreme Court has held that revenue or fees beyond nominal levels required to sustain will invite scrutiny from the tax department. So what will be the implications? Well, for statutory corporations like government bodies performing functions like water supply, housing, sewage treatment, Supreme Court has held that they perform public functions and therefore can claim exemptions. Statutory bodies like the ICAI for chartered accountants, the Supreme Court has held that only activities like prescribing standards and setting curriculum will qualify. Any further activities like coaching classes or registrations fees would be commercial and not eligible for exemption. Trade bodies, Supreme Court has held that commercial activities beyond advocacy may be impermissible. Similarly, non-statutory bodies like National Internet Exchange for India, they can claim exemption for performing a public function. State cricket associations, this is interesting here, could be in a spot of bother. Supreme Court held that they receive huge proceeds from sale of media rights by the BCCI. Supreme Court also recorded that they own stadiums and receive entry fees, sponsorships, as well as ad revenue. In fact, the Supreme Court has asked the tax department to review their accounts to check for eligibility. So it would be interesting to see if this judgment has any bearing on BCCI, which is also seeking similar exemptions. But experts are wondering now after this judgment that whether this case has raised more questions than answers, and that the Supreme Court could lead to differences in interpretation and possibly even greater litigation.
Ashmit, many thanks for joining us. Well, to take this conversation forward, I'm joined by Dinesh Kanabar, the CEO of Dhruva Advisors. Mr. Kanabar, always a pleasure. Many thanks for joining us. And let's address that question that Ashmit just raised. What will be the impact? What will be the implications of the Supreme Court order? Is it now going to lead to more interpretational issues and thereby more litigation?
Well, as I always say, the more the law is simplified, the more the law is clarified, the more it raises issues. And I'm not surprised that the Supreme Court judgment could create its fair share of issues. There are two judgments which came in yesterday, Shirin. One is in the context of an educational institution, where a separate set of provisions come in, which is Section 1023C. And then we have provisions relating to other charities. And as Ashwin rightly explained, what is general public utility and Section 11 to 13, which covers exemption of those entities. Let's first come to the educational institutions and what applies to them equally applies to hospitals. So there, what the Supreme Court has held is that, first of all, the sole purpose of these entities should be only to carry out either education or medical facilities. There were two earlier Supreme Court judgments which said that if predominantly they carried on those activities and there was something else incidental that would be permitted, the Supreme Court has reversed those judgments, which is a very rare thing to do, and recognizing that they are reversing a settled law. they have made those judgments prospective in nature. But what in effect it means is, and that is where probably the issue of interpretation comes in, the Supreme Court has sort of at one level gone on to say that entities which are involved in education or medical facilities should not do anything else which is understood, but they should not be making huge profits. Now, what does that mean? So they say that you could carry out activities and incidentally earn profits. And unlike in the later judgment where they have said that you should charge only on a cost plus basis, here they have gone on to say that if they make profits, that alone should not disqualify them. But what profits, how much profits has been left open. And if I look at the two judgments together, it is quite likely that the tax authorities on a going forward are going to say that educational universities, that hospitals will have to be providing services at or just a portion above cost and nothing more than that. They can't be making profits. So that's one judgment. The second judgment, and which is very, very important, which is on the slide which is coming on your screen, which is on the general public utility. Now, general public utility is very wide. It includes trade bodies, FICCI, CII, any other body which is of general public utility promoting sports, etc. And then the Supreme Court judgment is quite more lucid, unequivocal, to say that A, if these activities carry on activities only for academic profits, only for the principal activities for which they have been set up, no issues. But again, those profits should be nominal in nature. They should not be making huge profits. So it should be at or just a small portion above and nothing else. In the context of BCCI, which Ashmit spoke about, is very, very interesting. It has been held that the activities carried on by BCCI and by the state associations are indeed charitable in nature because they promote sports. So that has been accepted, not an issue. However, what the court has gone on to hold is that, as is evident from the sale of media rights, these entities carry on absolute commercial activity. And when the proceeds from sale of media rights are distributed to various state bodies, it has no correlation with how much money is spent on the development of the sport. So what the Supreme Court has said is that the tax authorities should examine whether there is a nexus between the earning of the activity and the money spent on sport. And if there isn't a nexus, then the profits will be taxable. So they have sort of put the can down back to the tax office. And I think it is going to be yet another round of litigation, maybe a decade from now. We're going to see further interpretations arising from that. That's the broad thrust, really.
Yes, thanks very much for giving us the broad thrust of the implications of these two orders. But what does this now mean from an IT department's point of view? The IT department has been very clear that they want to plug the loopholes that they believe were being misused, were being violated. The Supreme Court judgment now also bolsters the IT department's case. What do you believe will be the next steps now from the IT department in light of these orders?
So two things. Insofar as educational and medical institutions are concerned, they have been given time because the judgment is prospective in nature. They can recast themselves and ensure that their memorandum is only for those purposes and for nothing else. And they will need to ensure that they are not making bumper profits on a going forward basis. And the tax, and incidentally, that is retrospective, that is not prospective. So it is quite likely that the tax authorities will go back and say that if you are a medical institution or you are an educational institution and you are making profits and those profits are not incidental profits, they are substantial profits, then for those profits, the limit of 20% which is provided in law of overall receipts, if that is violated, it should be liable to tax. That's number one. Insofar as entities which are of general public utility is concerned, so take for example, and different type of institutions, quite a comprehensive judgment, Shirin. So take for example, a chamber of commerce. A chamber of commerce can carry on activities for dissemination of information, etc. But if, for example, it lets out its facilities and earns higher charges or things like that, or it does any coaching or things like that, then all those activities will constitute commercial activity and will be subject to the 20% threshold. Or take, for example, Institute of Chartered Accountants of India. Now, it can carry on the activities which are regulatory in nature, but again, if it lets out its facilities, if it does something more than what is prescribed as its core activity, then income arising from all of that, if it goes more than 20%, would be liable to tax.
All right, so we will have to see how this plays itself out. Remember, there are two orders that Mr. Kanabar there was taking us through the impact of. In some cases, as he pointed out, the changes are likely to be prospectively implemented, and there is an opportunity for institutions to be able to recast themselves in light of the Supreme Court order. But we'll also have to wait to see what further action perhaps comes in from the IT department in light of what we've heard from the Supreme Court. Mr. Kanabar, it's always a pleasure. Many thanks for joining us here on Business 360. That's it then on this edition.